Good afternoon, everyone. Please take your seats. We're about to begin. My name's Andy Varco. I'm a lawyer with Boyd & Gray and Associates here in D.C., and I am the chairman of the Federalist Society's Environmental Law and Property Rights Practice Group, which is sponsoring this fantastic panel. If you're interested in participating in the work of our practice group, please talk to me or a Federalist Society staff member after this session. We have a formidable group of panelists here today to talk about the highly important and controversial subject of navigable waters and the Clean Water Act. The moderator for our discussion this afternoon is Professor Jonathan H. Adler, who is the inaugural Johann Verhey Memorial Professor of Law and Director of the Coleman P. Burke Center for Environmental Law at the Case Western Reserve University School of Law in Cleveland, Ohio. In no particular order, among his many other accomplishments, Professor Adler is the author or editor of 7 books and very, very many articles. He is a regular contributor to the popular, useful, and enjoyable legal blog, The Vala Conspiracy. He has appeared on Entertainment Tonight, among other educational programs. And in 2018, he was elected to membership of the American Law Institute. So he is a big deal. Please welcome him.
Thank you. It's a pleasure to be back here. I'm going to stay seated because we've decided that this discussion will be best done some more as a discussion rather than seriatim lectures by our panelists. And the way to think about this program is this is the Goldilocks program about waters of the United States. We have one panelist that will tell you that the federal government is still trying to regulate too much, one panelist that will tell you that the federal government is now trying to regulate too little, and one panelist who will tell you that the federal government is getting it just about right. And you can figure out who is who. I'm going to also dispense with lengthy introductions because I know that there are materials about who we have, and I'd like us to be able to get directly into the substance. So I'm going to give a little bit of background about WOTUS and how we got here, and then we'll begin asking a series of questions to our panelists about our subject. And our panelists are Jeffrey Clark, to my immediate right, who is the Assistant Attorney General for the Environment and Natural Resources Division at the Department of Justice. So he ultimately is the one that has to defend what the administration does. To his right, only in terms of where we're sitting on the panel, is John Devine, who is Senior Attorney and Director of Federal Water Policy at the Natural Resources Defense Council. And then to his right is Tony Francois, who is a Senior Attorney at the Pacific Legal Foundation. For those of you that have the CLE materials, I believe there are copies of both the PLF and the NRDC comments, and perhaps I think as well the comments that I submitted on the proposed Waters of the United States rule. So for those of you who find that this discussion merely entices you to learn more about the subject, please consult those materials to learn more about what we're talking about. So a little bit of background. The issue before us is how we define WOTUS, Waters of the United States. This has been an issue that has been contested since the enactment of the Clean Water Act in 1972, or the Federal Water Pollution Control Act, what we generally refer to as the Clean Water Act. As some of you may know, when the act was first adopted, not even the federal agencies responsible for implementing it fully agreed or understood what the scope of waters of the United States over which they had regulatory jurisdiction consisted of. The act prohibits the deposit of materials or the discharge of pollutants into navigable waters of the United States, and the only definition of navigable waters of the United States that the act provides is the phrase waters of the United States. So how we define that phrase determines the range of areas, waters, and some lands that are subject to federal regulation under the Clean Water Act. When initially the Army Corps of Engineers disclaimed authority over at least some areas that could be characterized as waters, such as wetlands, John's organization, the Natural Resources Defense Council, took them to court in what was to be the first of many cases asking courts to clarify the precise scope of federal regulatory jurisdiction, a case called NRDC versus Callaway in 1975, in which federal district court held that the Army Corps of Engineers was trying to regulate too little. Much litigation followed in the ensuing years. If you fast forward to the 1990s, there was extensive litigation suggesting that the agencies were not regulating too little, but too much. And first in a case called Solid Waste Agency of Northern Cook County, and then subsequent in 2000, and then a case called United States versus Rapanos in 2006. The Supreme Court in both those opinions said that the Army Corps of Engineers and the Environmental Protection Agency were regulating too much. In the intervening period, one way to, as we heard from our last panel, one way to deal with uncertainty about the meaning of regulations and uncertainty about the meaning of statutes would be for agencies to engage in notice and comment rulemaking to, among other things, define the ambiguous terms that Congress enacted in the statute. But it was not until 2015 that the federal government decided, the Army Corps of Engineers and Environmental Protection Agency decided to go through a rulemaking and promulgate a rule defining waters of the United States. So it's often referred to as the WOTUS rule. It's the 2015 rule promulgated by the Obama administration, both responding to the Swank and Rapanos decision as well as trying to clarify the precise boundaries of waters of the United States. The Trump administration, as many of you know, when it came into office, one of the first executive orders that President Trump issued was an executive order to the EPA and the Army Corps of Engineers asking them to reconsider the 2015 WOTUS rule and to consider adopting a new rule that was adopted a more constrained view of federal regulatory jurisdiction and one that would leave more room for state and local governments to exercise their traditional authority in regulating land use and the like. At the end of last year, the EPA and Army Corps released a proposed rule, and that the notice and comment period for their proposed rulemaking just ended a few weeks ago. So that's a very super quick thumbnail history of kind of how we got to where we are. And to start off our conversation, I was going to ask Jeff Clark, since he is at the Justice Department, dealing with litigation that is left over from the Obama administration in terms of the challenges to the 2015 WOTUS rule, as well as litigation dealing with the Trump administration's efforts to both revise and replace that rule, to give us an overview of kind of where things stand in the courts, and then I'm going to turn to John and Tony to give us their assessments of the Trump administration's regulatory proposal. Jeff?
Thanks a lot, Jonathan, and thanks to the Federalist Society for inviting me. It's a particular pleasure to be seated next to Jonathan, who many moons ago was a summer associate, and I was at the very senior level of being a fourth-year associate at that time that we first worked together. And I think actually consistent with the panel structure, right, of kind of, you know, too much, too little, just right. Shouldn't I have been seated in the center? Well, in any event, I think those on my Judiciary Committee panel for my confirmation hearing would have stated that there is no one to the right of me. So, sorry, Tony, but at least the Senate or some in the Senate may disagree with you. Let me start before I talk about the background that kind of picked things up, more contemporaneously than Jonathan's deeper history, with one of my favorite quotations about the whole theory of federalism, which is from Justice Kennedy in the U.S. term limits case, that the framers split the atom of sovereignty. It was the genius of their idea that our citizens would have two political capacities, one state and one federal, each protected from incursion by the other. And to me, that can be summed up in something far more prosaic, which is that good fences make good neighbors, or good sphere delineations in the Constitution essentially make for good federal and state sovereignty partners. And I think that's largely, as in a thematic way, is what the administration's rulemakings in this area are about, which is trying to get to this Goldilocks position of having and respecting that it is possible for the federal government to engage in an incursion that goes into state authority, and that it's best to have sort of a proper respect for the spheres of what's best dealt with at the federal level and what's best, sometimes people say left to the states, but I don't think that really acknowledges the sense in which the state governments are part of the great constitutional design. And I don't think that in the Clean Water Act, especially using words like navigable waters, that Congress ever specifically or clearly intended to regulate all waters within the country. I think they intended precisely to respect the boundary between federal waters and state waters. So with that out of the way, and actually, Jonathan, I was going to cover 4 points: the 2015 rule, the applicability rule, the repeal rule, and the replacement rule. But I think you really covered the 2 points I was going to do about the 2015 rule and about the executive order that transitions to the last 3 things. So let me just pick up with the last 3. So the first of those topics is the applicability rule. On February 6, 2018, the agencies published a final rule that added an applicability date of February 6, 2020 to the 2015 rule. And that's what's called the applicability rule. They published the applicability rule to ensure regulatory certainty and consistent implementation of the Clean Water Act nationwide, while the agencies undertook further rulemaking to reconsider the 2015 rule and, where appropriate, develop a new definition of the, quote, waters of the United States. The applicability rule also determined that the agencies would continue to implement the previous regulatory definition, in other words, the 1986 regulatory definitions, the judicial precedent concerning those regulations, and applicable related practices and procedures in the meantime. Various states and organizations then filed challenges to the applicability rule under the Administrative Procedure Act in 4 district courts: the Northern District of California, the Southern District of New York, the District of South Carolina, and the Western District of Washington. On August 16, 2018, the district for the District of South Carolina granted summary judgment in favor of the plaintiffs in a case called South Carolina Coastal Conservation League versus Pruitt. And on December 4, 2018, that court clarified that it was entering a nationwide injunction and vacatur of the applicability rule. On November 26, 2018, the District Court for the Western District of Washington also granted summary judgment to the plaintiffs and purported to vacate the applicability rule nationwide in a case called Puget Soundkeeper Alliance versus Wheeler. The United States and other parties filed but later withdrew notices of appeal of the decisions of the to the Fourth and to the Ninth Circuits respectively, so there is no active appeal of either decision. Turning to what would have been my 3rd point, but is effectively my 2nd point, about the repeal recodification rule, which is also sometimes called the so-called Step 1 rule. On July 27, 2017, the agencies published a proposed rule to rescind the 2015 rule and recodify the 1986 regulations. The comment period on that closed on September 27, 2017. And on July 12, 2018, they published a supplemental notice of proposed rulemaking. The comment period for that closed on August 13, 2018. As stated in the supplemental proposal, the key rationales for repeal and recodification were these. Number 1, the 2015 rule would fail to achieve regulatory certainty. Number 2, the 2015 rule may exceed the agency's authority under the Clean Water Act. Number 3, the agencies had policy concerns regarding the broad scope of Clean Water Act jurisdiction under the rule. And 4, the 2015 Clean Water Rule does not appear to draw an appropriate line, again, my fence point, between waters subject to federal versus state jurisdiction as envisioned by Clean Water Act Section 101B. The fall regulatory agenda projected finalization of the Step 1 rule in March 2019. EPA's Office of General Counsel indicates that the date for finalization in the soon-to-be-released spring regulatory agenda is August 2019. So that's the current time frame. And my last point to cover relates to the replacement rule, or the so-called Step 2 rule. On February 14th, 2019, the agencies published a proposed replacement rule. On March 18th, 2019, EPA and the Corps denied requests to extend the public comment period there, which closed on April 15th. As Jonathan noted, that was quite recently. A public hearing on the proposed rule was held in Kansas City on February 27th through 28th of this year. And the fall regulatory agenda projected finalization for the Step 2 rule in September 2019. EPA's Office of General Counsel there indicates that the date for finalization in the soon-to-be-released spring regulatory agenda will be actually December 2019. So by the end of this calendar year, according to current plans in EPA estimates, as one of the two agencies along with the Army Corps involved in this rulemaking, by the end of the year, both the Step 1 and Step 2 rulemakings should be complete. And with that, I will stop.
All right, great. Thank you for that. So I want to first turn to John. John, your organization, the Natural Resources Defense Council, submitted comments to the EPA and Army Corps suggesting that the Trump administration has gone too far or is proposing to go too far
Absolutely.
in scaling back federal jurisdiction. So I was wondering if you could take a couple minutes just to walk through what you believe to be the deficiencies in what the Trump administration is proposing.
Sure. Well, just to tick off a couple of the low lights of what the proposal includes. It would eliminate protections for interstate waters, which have been in EPA regulations since 1973. It would exclude rain-dependent streams, of which there are roughly 2 million miles in the U.S. From Clean Water Act protection, plus likely other streams, given the nature of the definition that they have offered. It would exclude so-called isolated waters, which the 2015 Clean Water Rule would protect when they significantly impact the condition of downstream waters. It would exclude adjacent wetlands and ponds, except for a narrow set of ones that have specific surface water connections to other covered waters. That the combination of those two isolated and adjacent waters would likely knock out about half of the wetlands in the country, and expand a pre-existing exclusion for prior converted cropland, so that wetlands on such land that has ceased to be used for agriculture can still qualify for the exclusion. On top of that, the agencies also seek comment on a host of other things that would make the proposal far worse, like excluding streams that flow seasonally, which together with rain-dependent streams is about 60 to 70% of the stream miles in the country, several million miles, and accordingly a bunch more wetlands and ponds that are adjacent to those features. Perhaps revisiting the notion of what's considered a traditionally navigable water, and a bunch of other things. That's bad enough, just the upset to the status quo. But what is remarkable about this proposal is that it offers virtually no good reason to do it. The agencies have done paltry, is generous analysis of the impacts to water bodies, of the effects on Clean Water Act programs, the impacts of deregulation on public health, public safety, on fishing, and on recreational businesses, and on the economy. And at every turn, they say they lack the capacity effectively to quantify the impacts. And so at the end of the day, what you have is a proposal that says, we really want to do this thing. We don't know what it will do, but gosh darn it, we still want to do it. And that's the essence of arbitrary and capricious rulemaking.
And just in terms of what they should have done instead, should they have left the 2015 rule in place? Were there improvements that rule needed?
Well, maybe to blow up your Goldilocks metaphor, we thought that the 2015 rule was a very good rule, but that it actually left things out that the science would indicate ought to be protected to ensure the quality of waters across the country. But that goes to what they ought to have done, which is follow the science. And the agencies in this particular rulemaking have rejected the science outright. Not that they say that it's wrong, they're just ignoring it. And so it doesn't matter that wetlands that are in streams, floodplains, are critically important to those streams' condition, or that small tributaries contribute to the condition of downstream major rivers. We just don't want to regulate those features.
Tony, you, I think, have a slightly different view of the Trump administration proposal. Hopefully, sticking with my Goldilocks analogy, you don't think that the Trump administration has gone far enough, and I believe submitted comments on behalf of PLF to that effect. I was wondering if you could explain to us why you think there are still legal or other problems with what the Trump administration is proposing, or how the Trump administration is proposing to redefine waters of the United States.
Thanks. I want to echo others' thanks to the Federalist Society for the opportunity to speak here today, and also for all the other members of the panel. I think one day I will tell my grandkids about today, but it won't I probably will forget that I was on this panel, other than to say it's pretty cool to be the warm-up act for the Vice President of the United States. The comments we filed on the rule, I want to preface by saying that a lot of what's in our comments is critical of the rule or the proposal, but that the proposal is a long overdue, and we think several steps in the right direction of reforming the way that the agencies interpret the scope of their authority under the Clean Water Act. There are two main points in our comments. The first, dealing with both what we hope is a pretty robust textual analysis of the Act, supplemented with constitutional limitations on Congress's power in this area. I would say, if you grant the proposition that the Supreme Court seems to have endorsed 3 times, in Riverside Bayview, in Swank, and in Rapanos, that the Clean Water Act regulates something in addition to navigable, in fact, waters that were previously regulated under the Rivers and Harbors Act and predecessor statutes, that the Clean Water Act's coverage is navigable, in fact, plus. We argue that the agencies are mistaken in reading the plus part of that broadly. And you can look at our comments for the details of it, but essentially, we argue that the use of the words navigable waters means waters of the United States, including the territorial seas, indicates something very close to the phrase navigable waters of the United States in the Rivers and Harbors Act, and which the Daniel Ball case interpreted to derive the navigable, in fact, definition. So that even if, as the Supreme Court has said multiple times, the Act regulates more than navigable, in fact, waters, the text and structure of the Act still indicate that the plus has to be pretty closely related to navigable, in fact, waters. From there, what we basically do is, if you think of it as kind of like a film review or a book review, take as a starting point the executive order's direction to consider revising the definition of navigable waters consistently with the opinion of the Rapanos plurality. We think there's 2 basic problems with the proposal. The first is structural, which is that we read the proposal, and there's some discussion of this in the preamble, as trying to blend or harmonize or cohere in various ways the plurality and the concurring opinions in Rapanos. So the 2015 rule is largely built on Justice Kennedy's concurrence in Rapanos. It takes a much broader view of what the statutory term navigable waters means, and uses what Justice Kennedy articulated as a kind of multi-factor significant nexus test to determine which waters are covered by the Act. The plurality takes a narrower view. They hold that, or would hold, if they were the majority, that the Act only covers relatively permanent and continuously flowing water bodies that you would normally call rivers, streams, or lakes, and wetlands that physically abut them, that are right up on them, to use the technical term. But the way that the Rapanos plurality couches that is where the wetland has the kind of intermingling or boundary drawing challenge that the wetland at Riverside Bayview posed, then it can be regulated. But the wetlands that were more separated than that were not regulated. The way we read the proposal, it takes the plurality and the concurrence as kind of sideboards or sidelines within which the agency has, or the agencies have authority under Chevron to kind of pick a midpoint. Because what the proposal does is it regulates, it removes ephemeral tributaries from regulation, but it regulates intermittent tributaries. And the plurality does not allow for that, but the concurrence would. It also removes the significant nexus analysis that the current concurrence would require, but that the plurality would not require. So it's kind of a melding of the two opinions, and we think under the Supreme Court's precedence on how you read fractured opinions, that's not an available option. That legally, the holding of Rapanos, if there is one, under Marks versus United States, is either the plurality or the concurrence, but it's not some combination of the two. And so doing that would take you from the kind of odd situation which currently exists in the circuit courts of adopting Justice Kennedy's lone concurrence, rejected by all other 8 members of the court, as the controlling opinion, even further to say a view of the Act that no justice on the court adopted, but some midpoint between the plurality and the concurrence, is a reasonable interpretation of the Act and one that is available to the agencies under Chevron and in their interpretation of the Act. So that's kind of the structural issue there. The more detailed specific issue I alluded to earlier, which is that I think as a result of taking that analytic approach to what the Rapanos opinion does and says, the proposal regulates intermittent tributaries, and the plurality is as clear about intermittent tributaries as it is about ephemeral tributaries. They are not included within the Act's term waters. And I think one important thing to point out about the Rapanos decision, particularly the plurality, is that there's a lot of discussion in Swank and in Rapanos about the word navigable, but the plurality's opinion is really about what the word waters means. And in a footnote, Justice Scalia describes both ephemeral streams and intermittent streams as useful oxymoron. Everywhere you look in the opinion where regulation of ephemeral water bodies, ephemeral drainages, is criticized by the plurality, it is accompanied by similar criticism of intermittent streams. And so I think if what the agencies are doing is basing a new rule on the Rapanos plurality, it can only regulate actually continuously flowing streams. There, I think, are obviously some significant questions about how one would deal with seasonal drainages that the plurality does allow for the regulation of. And then just quickly to wrap it, there's a similar problem with the way that the proposal regulates adjacent wetlands. It allows for the regulation of wetlands that are not actually abutting regulated tributaries, so long as they have some surface water connection that can be intermittent to the tributary. And so we think that to actually do a regulation based on the Rapanos plurality, those are two major changes that the proposal needs to make. It needs to limit the regulation of tributaries to continuously flowing water bodies and wetlands that actually abut those tributaries or navigable and fact waters.
Okay, Jeff, you've heard that the administration has ignored the science of hydrological connection between various waters, and that it has ignored the legal limitations placed upon agency authority by the Supreme Court in Rapanos. Do you want to take a chance to respond and perhaps defend the administration's proposals?
Sure. I'll try to defend the Goldilocks position, keeping with Goldilocks. So first, caveat, which is that, look, we're talking, as I think all the panel members would agree, about something that is a Chevron question. And so it's very important to understand institutionally, right, that Chevron power is wielded by EPA and the Army Corps of Engineers here. It's not wielded by the Justice Department. We don't have final rules as I described it. And so, it's the final rules that will actually be, that which becomes the potential target of litigation from both sides. We will, consistent with the Constitution and the statute, provide as able a defense of that as we can. Taking John's remarks first, I guess I'm struck by it being a remarkable position to say that the agency's already acted in an arbitrary and capricious fashion before final rules have been issued. I think you're going to need, obviously, to look at the final record, to look at the final explanations from the agencies in the final rules, and then test those against the record for that purpose. The other thing I think to say is that from a Chevron standpoint, right, one difficulty that John may encounter in mounting arguments like that, assuming he's still unsatisfied with the outcome in the final rule, is that we're not dealing here with a statute that includes, text like it appears in the Endangered Species Act or some other statutes about, using the best available science or tying a particular regulatory determination to the best available science. Rather, we're talking about construing quite, broad terms like the waters of the United States as conditioned and related to another term in the statute, navigable waters, which Tony was exploring. And so that puts the questions and the basis for making arbitrary and capricious analysis and arguments on a very different footing than they would be if you weren't dealing with a broader statute. Turning to Tony's remarks and his argument that basically you have a narrower set of choices than you're imagining based on Supreme Court law about what happens when there's a fractured decision. To me, respectfully, Tony, and also respectfully, John, I don't think that grapples with a very important Chevron precedent from the Supreme Court, which is called Brand X, that basically, unless the Supreme Court makes clear when it construes the statute, and sort of by definition, you really couldn't have that if you had a fractured decision anyway. But if they makes clear that when they're construing a statute that they're doing so in Chevron Step 1 terms, then obviously agencies cannot purport to do something different than that. They're bound by that. But if they don't make that clear, then the agencies retain their full Chevron discretion. And so when you're talking about broad terms like navigable waters and the even broader term of waters of the United States, I think there's a lot of Chevron power there. And the fact that the administration may opt for a different spot than PLF may like, I think is something that's entirely consistent with Brand X.
So John, let me turn to you. I mean, Jeff raised the Chevron issue, and certainly one question in Chevron is the range of policy choice that the agency has in reaching its interpretation. And it seems that, at least as far as the agency is concerned, this is a policy choice, not a scientific choice. And I think in their defense, some things they might point to, one might be in Justice Kennedy's opinion in Rapanos. He wrote that environmental concerns provide no reason to disregard limits in the statutory text. And then I think they'd also point to the Science Advisory Board report that was a predicate to the 2015 rule, in which the Science Advisory Board acknowledged that significant nexus is a legal term, not a scientific one, and endorsed the idea that there is no scientific basis for determining the precise point at which a water goes from having a mere nexus to a significant nexus, but that ultimately that's a policy judgment. How do you respond to the claims that at least, that given that assessment of the science, that assuming the EPA and Army Corps provide a fuller explanation of the choice they ultimately make when finalizing the rule, they don't have to worry about NRDC's view of the science or the judiciary's view of the science, because they're ultimately allowed to make a policy choice along this continuum under Chevron?
Sure, a couple things. Well, first, that policy choice has to be at least basically reasonable, and at least so far they have not evinced that based on the record that the agencies have before them. But even assuming that, waters of the United States is a ambiguous term that they have the ability to interpret, they can't do that completely acontextually. And the entire purpose of the Clean Water Act, something we haven't yet mentioned in however long we've been up here, is actually is restoring and maintaining the physical, chemical, and biological integrity of the nation's waters, which in 1972 was crappy. And unfortunately today still ain't so hot. More than half of stream miles assessed in the country don't meet state water quality standards. It's higher than that for lakes and ponds and bays and estuaries. And so any approach to defining the pollution control programs of the Clean Water Act, which the linchpin Waters of the United States term triggers, has to respect that water quality goal. And so while the Justice Kennedy's significant nexus test might not be itself strictly necessary or legally commanded, our view is that any definition has to be consistent with those fundamental purposes of the Act and has to show how it's advancing those purposes. The proposal doesn't do that. There's no linkage that I can discern between the proposed regulation and water quality.
So Tony, what of that? We've heard you've talked some about the importance of the definition of waters, the importance of the idea of navigability, but certainly many would argue that when we interpret a statute, and particularly when we interpret in potentially ambiguous terms within a statute, we do so in light of Congress's purpose. And here we don't have to guess at Congress's purpose. We don't have to dig through legislative history. We can, in fact, read the findings of the 1972 Clean Water Act itself, and they say that restoring the integrity of the waters, or restoring and maintaining the integrity of the nation's waters is supposed to be the primary focus of the EPA and Army Corps. Doesn't that support a broader understanding of what waters are regulated?
Well, it would depend on what the Act's other stated purposes, which is sort of generally articulated with the shorthand of federalism. But, in Swank, which is echoed in the Rapanos plurality, the Supreme Court held that under the clear statement rule, a reading of the Act which was broad enough to insert federal regulation into traditional areas of state sovereignty like land use and the allocation of water resources. But I think land use is a particularly important aspect of this, that the court would not read the Act to extend that far, absent a clear statement from Congress that it intended that. And the Clean Water Act actually specifically states the opposite, which is that it is intended to respect traditional state sovereignty over areas like that. There's a little discussed subsection of Section 1251 of the U.S. Code that actually affirms state regulation and control of water rights. And, that's not limited to water rights derived from, small or distant water bodies. I mean, essentially, the Act says, in that particular case, if you are constructing a diversion work on a navigable, in fact, water under state law, the Clean Water Act is not intended to interfere with that. So I think that counterbalances how you read, again, the breadth of the plus in navigable waters plus. And, just briefly add that the way the Act is interpreted and applied by the agencies in the field, it does extend in practice into areas that you would, I think, generally agree would be traditional areas of state regulation, farming, home building, and involving people that are just kind of going about their business, doing things that the Act would not give them fair notice or actually regulated by it.
I'm wondering, Tony, also what you would make of the Chevron point, because I think one of the arguments that would be made, and certainly that the administration would argue, is that it may be the case that Justice Scalia's plurality may offer the best or least bad way to resolve the meaning of the phrase waters of the United States, but insofar as that phrase is ambiguous, the agency under Chevron is allowed to adopt any permissible interpretation. And it would seem that the Justice Kennedy significant nexus test, which at least is arguably based upon the Supreme Court's holding in Swank, would, if not the best interpretation of waters of the United States, would still at least be a permissible one under Chevron, and that while your arguments might be persuasive as a policy matter, aren't the sorts of arguments that a court should embrace to overturn an agency's authority.
The first part of my response to that is that while the Supreme Court has frequently criticized the agencies for not doing rulemaking that clarifies the scope of the Act, the Supreme Court, sooner or later needs to take a case that resolves the ambiguity that it propagated with its fracture decision in Rapanos. I think that there's responsibility, in both of those branches of government, as well as, Congress could do something to clarify it. I think that it's a difficult argument that the particular blend of the plurality and the concurrence that are in the proposal are a permissible interpretation of the Act, given that both the plurality and the concurrence reject the regulation of what they describe as mere trickles. And the way that the proposal would include intermittent streams that flow as little as a few days beyond what an ephemeral drainage would. It's, I think, difficult to argue that that's a permissible option. It's true you don't have a binding Supreme Court opinion on that, but where 5 members of the court have said that's outside the scope of the Act, based on different rationales, of course, I think that's a harder argument to make than that you have to pick either Rapanos or you have to pick either the plurality or the concurrence as the holding. The final thing I'd say on that is that a lot of the, we think at least, a lot of the discretionary decision-making difficulties that the agencies face in revising the 2015 rule are simplified if you take the legal position that the plurality is the holding of Rapanos. That if that is the case, and I think that's a defensible legal position, the plurality provides you with a far narrower range of discretion for what to regulate than a blend of the two or the concurrence, and that makes a lot of the rulemaking problems that are inherent in this easier to surmount.
So one quick observation, just so people understand, while I can't prejudge what the final rules will say, one thing I can safely say is that I think the 2015 rule did go too far, since I think that's implicit in the executive order from the president and in the whole idea of proposing rules to change the 2015 rule in the first place. To me, one of the most humorous and striking things you see when you look at the 2015 new regulatory definition is the fact that there's a specific exclusion, and I kid you not, if you haven't looked at the rule, for puddles. And you don't need an exclusion for puddles unless puddles might otherwise, be something that one could make an argument would be included in the rest of the rulemaking. But the main thing I want to address, I think, is the whole notion of the purposes of the Act. So it's frequently said that the purpose of the Clean Water Act is to preserve the chemical, physical, and biological integrity of the waters. Several responses to that. As Tony was pointing out, that's not the only purpose of the Act. The Act also specifies many specific stopping points, and it also includes a very high-level purpose about protecting federalism and respecting the primary role of the states in protecting their own waters. And I think it often gets lost in this that states do care about their own waters, right? The rulemakings that the federal government does should not proceed on the assumption that the states, have a devil-may-care attitude about their own waters, and only the federal government can protect those waters. That's contrary both to the constitutional theory of federalism and to the text of the statute and the purposes that it enunciates. The second thing is that even if you're going to compare purposes together, the Supreme Court has said several times that no statute pursues its primary purpose at all costs, which is a very important canon to keep in mind. And the third thing is, also as Tony pointed out, but just to put a slightly finer point on it, in Swank, the Supreme Court held that the constitutional canon, the Ashwander canon, to avoid constitutional questions here, those related to sort of taking over land use regulation based on regulating wetlands, as something that may be permissible in some instances under the Commerce Clause, is something that you need to keep in mind so that you don't overconstrue the statute and trench too much, have incursions, as I was starting with, too much on the state sphere.
So John, you've heard that protecting the integrity of the waters is not the only purpose of the Act. Preserving the traditional state role in regulating land and water is also a purpose of the Act, and that at least in Swank and arguably in Rapanos as well, the Supreme Court seemed concerned about allowing the agency to adopt an interpretation of the Clean Water Act that would stretch or put tension on the limits of the federal government's enumerated powers, if not exceed them. How would you respond to those sorts of concerns?
Sure. It is, in fact, the only objective of the Act. The Congress in Section 101 declared the objective of the Act to restore and maintain the chemical, physical, and biological integrity of the nation's waters. Had several policies and goals to effectuate that objective. One of which is, as both folks here have said, respecting states' really unremarkable authority to implement the Act, which they do right now in virtually every major respect that the program is run. State governments, all but I think 5 are the primary permitting entities under the Clean Water Act. They establish state water quality standards. They do a host of things. And this rule would upset, in my view, the longstanding balance between federal and state authority under the Clean Water Act, where Congress charged EPA with setting basic statutory minima or regulatory minima for how states have to act, and then overseeing their implementation of it, making sure that permits are adequate to meet the goals of the Act, making sure that state water quality standards are consistent with the science and sufficient to meet the goals of the Act. The notion that this provision in the first section of the Act had some other magical force. Heretofore, unannounced in the 50 years virtually of implementation and litigation under the Clean Water Act is new as of this administration. And so, you know, again, I come back to what are we trying to accomplish here with this law and then with this regulation? And does this regulation have anything to do with the objective of this law? And I defy you to show me something in the record of this proposal that says we're going to come closer to, we're going to better serve Congress's objective of making the water cleaner. It ain't going to happen because the feds are running away from their responsibility.
And what about the constitutional concerns? Or do you think those are overstated? And just to give a little bit of background, after the Supreme Court's 1995 decision in the United States versus Lopez, in which the Supreme Court struck down the Gun-Free School Zones Act for exceeding the scope of Congress's power to regulate commerce among the several states, Richard Lazarus, environmental law professor at Harvard, wrote a column in the Environmental Forum published by the Environmental Law Institute saying that the then existing definition of the waters of the United States in federal regulations was clearly in excess of what the Supreme Court allowed in Lopez. And in the column, he urged the EPA and Army Corps to revisit their regulations. In light of Lopez, they didn't, and arguably that's what led to, at least to the Swank decision. Was that just a brief period in time where the constitutional constraints were real? Are the constitutional constraints surmountable? I mean, how would you respond to concerns that focusing purely on ecological interconnection and the effect of one water body on another presses against constitutional limits?
Well, I'd say that they are surmountable. That SWANK stands for the proposition that the particular interpretation that the Reagan administration adopted in saying that if a water body is used by migratory birds, it qualifies as a water of the United States. That interpretation went too far. Not that it was unconstitutional, but that it pressed up close enough to the Constitution that Congress had to authorize it more explicitly. And so that's the length and breadth of constitutional rulings on the scope of the waters of the U.S. You can't regulate water bodies merely on the presence of migratory birds. When you look at the rule that the Trump administration is proposing to replace, the 2015 rule, linkages to interstate commerce or potential links to interstate commerce are gone. It's entirely based on impacts that water bodies have to navigable waters, and therefore there's a clear hook to the Commerce Clause that way, that the only things that are being protected by the 2015 rule are those things that the scientific record demonstrates contribute to the quality of water in traditionally navigable waters.
Tony, the statute that Congress enacted is the Federal Water Pollution Control Act. We call it the Clean Water Act. We don't call it the Federalism in Control of Water Resources Act or the vertical separation of powers in Regulating the Environment Act. How do you respond to concerns that ignoring hydrological connections between various water bodies, between wetlands and waters, and failing to account for them will result in a regulatory regime which fails to maintain existing water quality, let alone improve it to the levels that Congress set out as its goals in 1972?
I can't resist repeating what Justice Scalia says in the Republic Plurality. In response to the government and their amici's arguments along these lines, that the Clean Water Act is not a comprehensive National Wetlands Protection Act, and that the question is, what did Congress authorize? There are some constitutional limits on that, but I would grant the proposition, because I think it's true, that what this plus is in the Navigable, in fact, plus, the Act provides very little, if any, guidance on. I think I think in a general sense, the argument for a broad reading of that in order to effectuate a policy objective is not inherently unreasonable. But I don't think that that's the correct reading of it based on all the other ways in which waters are described in the Act. All of the other implementation goals that are in 1251 use very broad terms, the nation's waters, or just waters generally. And so there's clearly some limiting principle intended in the phrases navigable waters and waters of the United States, including the territorial seas. And the similarity of those terms to the Daniel Ball term, navigable waters of the United States, has to be given some significance in construing that together with the Rivers and Harbors Act. I think that the concern about what happens to waters that are not regulated under the Clean Water Act really depends from state to state what state you're talking about. In California, I would tell you right now, developers and other business interests would love to stick with the Clean Water Act. They do not want to be thrown to the wolves of the California State Water Resources Control Board. The other states, I think, the way to approach the policy objectives that John is articulating is to lobby those state governments. But in a lot of states, there are state level controls. I think it's worth looking at how stringent they are and how rigorously they are implemented. But I think the bottom line is, what did Congress actually authorize? And I think that the Chevron discussion illustrates a basic problem here, which is that if the act itself if the term is vague, if waters of the United States, including the territorial seas, is vague, at a certain point, it may be too vague. And if the only way to know what that's, I occasionally offer a soft defense of Nancy Pelosi's famous gaffe that we'll have to pass the Affordable Care Act to find out what's in it. She's not wrong. We were talking at the lunch panel about all of the policy choices that were made post-adoption of the law. If the only way to know what waters of the United States means is for the executive branch to interpret it, then I think there's a real void for vagueness problem in that aspect of the statute. And I think that's why Justice Alito described it as hopelessly vague in his Sackett concurrence. I think that's why Justice Kennedy himself, during the Hawks oral argument in 2016, mused that the act might be unconstitutionally vague, and that the way to avoid those problems is to interpret the plus narrowly.
In a minute, we're going to turn to questions from you. Do we have a microphone that folks can line up behind?
You'll just have to speak.
We don't have the microphone. So, I have a couple quick questions I wanted to raise first. John, and one thing you criticized the Trump administration's proposal for is not identifying enough reasons for departing from the 2015 rule. What would you say to those that would argue that litigation risk is in and of itself a justifiable reason to change a regulation? I think one of the things the proposed rule points to, and certainly one thing this administration has pointed to in other contexts, is when lower courts have suggested or given indications that they are suspicious of the validity of rules that are on the books, that is a good justification for agencies to revisit them. Is that not a good justification here, or do you think that's a misreading of the tea leaves of the initial challenges to the 2015 rule?
I'm not, I think the policy ought to reflect the agency's mission as defined by the statute. And here, I'll say again, it's about water quality. If the agencies are truly worried about specific aspects of the 2015 rule surviving, well, they're not defending it in any of the ongoing litigation. So, we could have started with a proposal to amend the 2015 rule, okay. This part of the 2015 rule might be too broad, might not be working. What's remarkable about that last point is that in none of these regulatory actions, either proposing to repeal it or proposing to replace it, have the agencies actually looked at the implementation of that 2015 rule, which it has been implemented for quite a while in many states. And so the agencies have hundreds of records of how it's been implemented on the ground in specific places, applied to specific situations. And the agencies have steadfastly refused to analyze those records to see, does the 2015 rule accomplish what it set out to do? Does it provide clear answers in the majority of cases?
So Jeff, one thing the administration could have done is instead of proposing to repeal the 2015 rule, it could have proposed modifications. And I guess related to that, if the administration suspects that the 2015 rule is too broad under the Clean Water Act, is it really tenable that the 1986 regulations are tenable? Because after all, those are the regulations that Richard Lazarus said were clearly out of bounds post-Lopez and are arguably as, if not more, expansive than the 2015 rule. So is there an argument that the administration should have instead said, maybe 2015 rule is still too far, but let's shave it on the edges rather than throwing it out and risk having an even broader rule in place for a period of time?
So, Jonathan, the first thing I think is that the applicability rule and its kind of reversion, I think those questions are largely mooted based on kind of the status quo of the nationwide injunctions and the forthcoming rulemakings. The other thing I guess I would point out is that it's one thing to use litigation risk as a factor. It's another thing to make it the exclusive factor. So returning again to the statute and to the Chevron powers given the broadness or ambiguity, related ambiguity of the statute, to me I think John is arguing for a one-way ratchet approach to the statute, that it just sort of gets more and more and more stringent over time because that's the only thing, after all, consistent with the purpose of the statute if you conceive it to be narrow. And I don't think to be that. And I don't think that's correct. I think that the point of these proposed rulemakings is that it's entirely within the fair game of the agency here to propose stopping points for what point you don't pursue that primary purpose, even if you concede that is the primary purpose, and in which you kind of don't go all the way on that because of other cross-cutting purposes. You need sort of another blade of the scissors to do the cutting at where you make the policy choice. And to me, that comes back to my spheres point, which is that there are really three spheres in the federalism area, right? There are things that the federal government does exclusively, wielding the power of preemption or constitutional assignment. There are things the states do exclusively. And then there are areas of concurrent power. And in those areas of concurrent power, you need some sort of place, and this is what the statute gives you, and the exercise of executive authority, deciding how far to go in an area in which you have concurrent jurisdiction. And I think that's all the proposed rulemakings are doing.
We now have a microphone. Should people line up by you, or if folks want to raise their hands, we can get the microphone to you? Okay, so questions right here in front here.
Thank you. Jonathan Wood with the Pacific Legal Foundation. I'm wondering if I can unite the left side of the panel by proposing this. There's an exception for Chevron for questions of major questions of economic, social, and political importance. And whether you approach that question from the perspective of the economic impacts on regulated parties or the environmental and ecological impacts of this question, it seems to me that this is a clear situation where that exception has to apply. So ultimately, isn't this something that the courts have to decide without deference to the agency? And if they get it wrong, Congress has to fix it?
So John and Tony, can we unite you on this is not a question that we should leave to the agencies, but in fact has to be resolved by Congress, or the courts, if courts and then Congress?
Can't say I've thought about that particular wrinkle on it. I guess I would say that I have a maybe parallel view, which is that there's a line of cases in the Clean Water Act that that the agencies can't refuse to regulate things that are clearly point sources within the definition of the point source. And I would say the same holds true for something that's clearly a water of the United States, given the purposes of the Act. And so if the agencies are disclaiming authority over something that has clear import for the nation's, for water quality in all kinds of features that are traditionally navigable, then they don't have that interpretively way, if you will.
Tony, is this a major question?
Well, that's actually, I think, kind of an interesting historical way of looking at it, because the agency has not fared well in getting Chevron deference in Swank or Rapanos, and Chief Justice Roberts' concurrence in Rapanos says, give us anything reasonable and you'll get deference on it. I don't know, so that's 2006. I don't know that that's the same Chief Justice Roberts today. I mean, I don't, just the development of the major questions doctrine since then suggests that this is an area where it's going to be more difficult than usual to get Chevron deference, and that in that respect, you still have to figure out what the terms of the Act mean, what the range of ambiguity is. And you know, I think the answer winds up being, you know, the court has already said in Swank, if, you know, unless you find a clear statement for it, we are not going to interpret it broadly enough that you're going to invade land use permitting. That might I mean, that certainly overstates the facts of Swank, but that's definitely the principle in Swank.
Additional questions?
This is a question for John, and you made the comment the waterways they've got a long way to go to be where they need to be, but I think you would agree, like in the last 2 to 3 decades, there's been substantial improvement.
Yes.
And my question kind of comes around that internal waterways, creeks, rivers, and all that are much cleaner. I'll use the Hudson River as an area of a lot of improvement. Sturgeon come further downstream every year. Do you worry that your approach is so rigid, actually almost force-feeding new regulation on people, that you'll drive people away from this when the natural kind of process is we're seeing cleaner creeks, tributaries, we're seeing developments on those areas where people will pay premium prices, and they're very pro-clean waterways. And I just wonder if there's a concern on y'all's part by being so aggressive that you may drive people away from being more supportive of clean, better waterways.
Thanks. Well, I guess I would say, yes, I entirely agree that the world is better off now than it was in 1972. And I guess I would say, what happened in 1972? Well, we enacted the Clean Water Act, and we started enforcing it. And as Jonathan was saying just a minute ago, the implementation of the law was actually quite strict through the 80s and 90s until Swank. And if anything, the 2015 rule is as I said earlier, weaker than historic regulation, but still better than the mess we had before it. And to me, the notion that given the success of the Clean Water Act, I grew up near Boston, and we'd go into the city. My mom would tell me, don't even touch the Charles River, never mind swim in it. And now they have, people swim in it. People are on it all the time. The Chesapeake Bay is on its way back. It's not there, but it's on its way back because of the Clean Water Act. Lake Erie is no longer dead, although it still has huge pollution burdens and that threaten drinking water supplies and the like. And so, given the success of the Act, given that we're not yet near where we need to be, it seems to me the exact wrong time to walk away from that success.
Time for, I think, one more question before we have to line up for security. Is there a final question, or should I come up with one? Okay, I'm going to ask a question then, since I don't see one that has been raised, and I'm curious as people think about this. There's been a lot of debate more broadly about the appropriateness of nationwide injunctions against federal agency actions, as opposed to confining relief to either the parties to the litigation or to the jurisdiction of the courts in which the claim was brought. And I'm wondering whether any of the panelists have thoughts on whether or not this sort of rule, given the interconnection of waterways, makes it more or less appropriate for national injunction or universal injunctions, as some people call them, as a form of relief in this sort of litigation. And I'm sure Jeff has thoughts of that. I don't know about that. I don't know if the others do as well.
Just quick thought. I think after the Supreme Court's decision in the case about how Clean Water Act rulemakings are supposed to be reviewed, namely that they're supposed to be reviewed in the district courts and not in the courts of appeals, that inherently for that system to work, it has to be that you can have ferment and differences among the district courts that then bubble up to the courts of appeals, that then you can then look to see whether there's a circuit split and get it to the Supreme Court. Having nationwide injunctions is fundamentally inconsistent with that system, beyond the fact that, and there's a memo from DOJ on this that I urge everyone to look at, it's on the website, about how nationwide injunctions are being massively overused and why they're legally problematic.
John, Tony, any thoughts on nationwide injunctions?
I think the ultimate resolution on the merits of these, I'm not sure if this is particularly responsive, of any of these lawsuits, just like it was in the case of the suspension rule, is either vacature or not of the rule. And, there may be interim, preliminary injunctions, but the resolution of the merits of these cases will I think be whether or not it will be nationwide. It will be either a vacature of the rule that after it bubbles up through the litigation is concluded, or it will stand.
We've actually had both over the 2015 rule, as the Sixth Circuit had stated nationwide for a period of time. From our perspective, representing our clients, I mean, we've filed our cases in multiple states to simply avoid the whole question of whether or not clients filing in one state but from another state would be entitled to injunctive relief, at least preliminarily. I do think that the disparity of results in the various preliminary injunction motions to date. The Sixth Circuit was the first recently to deny a preliminary injunction against the 2015 rule. Advances the prospect of a final decision on the merits of the 2015 rule. And despite the Justice Department's obvious obligation to defend the rule, a final ruling on the merits of the 2015 rule would significantly advance the resolution of what happens next.
Two little tidbits. Currently, in case you were curious, the 2015 rule is in force in, 28 states or 22?
22 states.
22 states in the
Although
District of...
a few states have
Right,
also
and then-
subsequently withdrawn from litigation against it.
So close to half of the country is currently under the 2015 WOTUS rule, and approximately half is under the 1986 regulations. This disparity in what wetlands or Clean Water Act rules apply in what states is not new. As some of you may know, under a decision called Tab Lakes, from the pre-Swank era, the Fourth Circuit had actually invalidated the migratory bird rule just within the confines of the Fourth Circuit. So we had a period of time prior to Swank where migratory birds were a basis for federal jurisdiction under the Clean Water Act in all of the country except for those 4 states. Anyhow, it's time for us to line up to hear the Vice President. So please join me in thanking our panelists for what's been a great discussion. And we are adjourned.